Employment Law This Week. I'm George Whipple. Our top story, San Francisco and New York State break new ground on paid parental leave. Starting in 2017, businesses with more than 50 employees in San Francisco will be required to give new parents 6 weeks off, fully paid. San Francisco is the first city in the U.S. to require full salary for new mothers and fathers during their time off. Meanwhile, New York State has passed the most comprehensive parental leave policy in the country. New York State's legislation mandates 12 weeks of partially paid leave for all new parents by 2021. An NLRB memo outlines top enforcement priorities for 2016. The General Counsel for the National Labor Relations Board has issued an internal memo that offers employers insight into his office's initiatives and emphasis this year. The memo describes the types of cases that must be submitted to the Division of Advice for review, rather than decided by the regional office where the charge was filed. Among other priorities, the General Counsel wants to expand employees' rights to organize and communicate using company resources, cut back on employer rights in bargaining, and grant significant new rights to non-union employees. Steve Swirsky has more.
The memo and the GC's priorities really tell us several things. They tell us that this board and this General Counsel continue to be activist. They are looking to expand the National Labor Relations Act's reach into non-union workplaces. They are looking to change existing law in collective bargaining, for example, the right of employers to hire permanent replacements during a strike, the rights of employers to implement their final offers in bargaining. What it tells us is that the board is continuing to press, and the General Counsel is continuing to press, to extend rights in ways that never were done before to employees who don't have unions and are not represented. There's a good chance this will continue, not just into 2017, but beyond, depending on the outcome of the election.
The EEOC targets health history forms on job applications. The Equal Employment Opportunity Commission has brought suit against Grisham Farm Products for requiring job applicants to complete a 3-page health history. When a recent applicant refused to answer the questions on the form because he would have been forced to reveal a disability, he was told that he would not be considered for the job. The EEOC has filed suit against the company for violating Title I of the ADA with its health form requirement. The agency also alleges that this is a violation of GINA, which bars employers from requesting or requiring genetic information from applicants. The DOL softens its final fiduciary rule for retirement advisors. The Labor Department has released its long-awaited final fiduciary rule with some notable changes after the comment period. The new regulation still requires brokers for individual retirement accounts to act in clients' best interests and expands the definition of who qualifies as an investment advice fiduciary. But in the final rule, the Department has made some concessions to opponents of the regulation. These adjustments include a simplification of the best interest contract and a grandfather provision that prevents the new standard from applying to recommendations made before the rule goes into effect. And that brings us to our tip of the week. Brian Rauch, General Counsel for Harvard Maintenance, is here with some advice on dealing with unions around the country.
Traditional labor law and labor relations is an important area of focus for General Counsel of both union and non-union companies. For example, in a unionized environment, General Counsel must be aware of the different relationship between he or she and union counsel. That relationship is built on mutual trust. You're going to see a union representative multiple times throughout your career, if not almost every day. Therefore, building that relationship of trust is more important than a one-off victory on a single issue. For non-union companies, the General Counsel also must be aware of traditional labor law issues. For example, the joint employer relationship has become an increased area of focus for the National Labor Relations Board. Under the joint employer standard, you can be responsible for the actions of another employer with respect to that employer's employees. if you retain any sort of control over that company's employees, the National Labor Relations Board has held in Browning-Ferris that you can be responsible under a joint employer standard of liability. That means you could have financial liability or even union recognition obligations under the joint employer standard.
Thanks, Brian. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.